So, uh, so today again, let's delve into the complete patent processor. I'd like to thank Sunit ji who joined again. Sunit Mantri. Good evening, sir. Um, so let's jump into the process of requirements for the complete patent application for any.
Hmm. Yesterday we could complete very few questions of yours.
Yeah, that's right.
We had a meaningful discussion related to the fees and all. Yeah, as we discussed yesterday, the first step is to go for a patentability search for a startup or for anyone actually want to file a patent application to see the citations globally because these will be cited by examiners and at that point in time like we cannot actually add anything into the description or amend the claims which is not the original which are not from outside of the claims which are originally filed.
Yeah.
So that means like we should be sure with citations what we have uh, on date
Yes, sir.
before actually filing our patent application, and the patent application can be always suggested it is a complete specification to avail the early examination. If not, or if the inventor is not ready to provide experimental validation or comparative data uh, based on the type of invention, then in that case only it is suggested to file a provisional specification uh, and get a priority. And within no time, though they will have 12 months time,
Okay.
within no time actually they can file their complete specification.
Okay.
And requirements for complete patent application, that is complete specification, is it requires a detailed description and supported by drawings.
Okay.
And in case of an invention which is talking about energy efficiency, water quality, or physical or chemical properties of the product, like in food or maybe drugs, and any device which is talking about efficiency, then in that case definitely we need comparative data.
Okay.
So that data is very much required in the detailed description, and drawings are very much required. Even drawings explaining the scenario. In certain cases, if it is an automobile or maybe some sort of a moving object that we are claiming, that case like what is the in a scenario drawing showing like all the components or maybe the data transfer between between different aspects of the division, aspects of the invention. So we have to show scenario drawings, and then the device drawings. It's a cross sectional view or maybe exploded view, showing all the components, how they are actually constructed, how they work. So to explain this detailed drawing, there is no limitation on number of pages,
Okay.
but overall 30 pages is the count that the patent office accepts within the fee, or otherwise if it is crossing 30 pages, like we have to pay additional fee. But with respect to like there is no stopping if the description needs more number of pages, so we should be giving it.
Okay. So after 30 pages, will it be the double the fee, sir? In
Uh,
case if there is
the application fee is 1600 in case of natural persons, startups, or small entities, or in case of normal entities, it is 8000. So each page, additional page after 30, will be charged rupees 160, and
okay.
each claim after 10 will be charged rupees 320 for the subsidized category like natural persons or startups or MSMEs or institutions,
Okay.
and the same into 5 times, like 160 into 5 times for normal entities. It's all 1:5. There are
Okay.
only two categories as discussed yesterday. Previously, there are three categories: 1x, 2.5x, and 5x.
Okay.
Now all the 2.5x category applicants, like small entities, are actually given subsidy.
Okay.
It is 1x and 5x. So 5x category applications are only 5%, and now whatever we have 1x category is 95%, because all the applicants, all the types of applicants are actually brought into 1x category, whatever it is.
Okay.
So each additional page, 160 rupees after 30 pages. Each additional claim after 10 claims is 320 rupees. So need to be paid additional.
Okay. That's great, sir. I'd like to thank Sunichi who tuned in live. So, quick question to Harisai. What is Section 10 of the Indian Patent Act? Hari, you can unmute and speak. If you don't know it, just give a thumbs up.
Hello. Yeah, hi sir.
Yeah. What is Section 10
Am I
of
audible?
the Indian Patent Act? Like, is there anything would you like to add apart from what Srinivas sir just mentioned with respect
Actually,
to?
section 10 of the hello.
Yeah, please go ahead.
Actually, section 10 of the Patents Act deals with the drafting of the applications,
Oh,
provisional and complete specification.
okay. Okay, apart from drafting up the application, so with respect to the requirements of this patent application, what else can be done? Like, do we need to disclose the complete invention or, um,
Yeah, it depends upon the inventor how far he had come with his invention.
okay,
So if he's not yet concluded his invention, so he can go for provisional application
okay,
without claims. If he concluded his invention, so he can obviously go for a complete application,
okay. That's great. Thank you so much.
including his claims.
Yeah, thank you so much, Harisai. Would you like to add
Thank you.
anything, Srinivas sir, before we hop on to next question for the Section 10 of the Indian Patent Act?
Yeah, Section 10. Why Section 10 is very important is, as we are discussing about the sufficiency of the disclosure.
Okay,
So Section 10 of 4 speaks about sufficiency of the disclosure, and this is the key objection in almost 70% of the examination reports. Uh, the reason could be multiple. Reason is the inventors are not aware of how much description they have to put into the application, and even agents are maybe paralyzed in a state where, like, the due date is very near, and the inventor has very less information to support, or inventor provides less information.
okay,
And in those cases, like, 60% applications, 6 out of 10 applications will have a deficiency of disclosure, or maybe clarity uh, missing in terms of, they claim something and they cannot actually support with the description.
okay.
And this why we are talking here, when we are talking about complete specification,
Mhm.
is because of that. So Section 10 is important. It definitely on top of chapter, Section 10 says, like, it all deals with provisional specification and complete specification. But if we drop down on it, so 10 of 4 speaks about the sufficiency of the disclosure, which is very important.
Okay. So how are they drafted, sir? Like, with respect to the role of patent specifications, uh, how are they drafted? Like, with respect to these patent specifications, how are they drafted?
As discussed, claims and description is the key critical part of the patent application. So claim is the thing which is validated, or first, if a patent examiner or a person like me, or maybe someone looking for some citations, after search, after he gets that PDF or maybe the web link where he can see all the contents of the patent application,
Okay.
he first reads the abstract
Mhm.
to know very brief about what the invention is, and then he looks at the drawings, and then after looking at the drawings with the numerals given in the drawings
Okay.
to each part of the each part of the invention, So he'll correlate that with the claims. Like he'll read the claims
Mm-hmm.
so that he can understand what the inventor of this particular application is claiming, or what is the invention or the grant is all about.
Okay.
So role of patent specification and what is the part in it which is very important is the claims, and claims supported by description, and the description supported by the drawings.
Okay. So all these drafts require some any legal support, sir, or anybody like, do they need legal expertise, or can any layman just file it with the required technical uh,
If the
description?
technical information is properly written, so there is no point of legality in it. It's all English. Um, if the technical part is written such a way, it should be exhaustive. At the same time, it should be not opening any pitfalls in our own invention.
Okay.
Example, we have. I am taking example. So someone came up with a invention saying he developed a rack of batteries for an EV scooter.
Oh, okay.
He just developed a rack.
Okay.
We already know racks for computers, maybe racks for the network room or something, right? So
Yeah, that's
we
right.
will have a rack wherein we can place the switches, the modems, and a separate section of maybe power adapter or something, so
Okay.
that we can have power connections within the rack, and modems and other hardware is placed in within the rack, and it is dust free so that it is covered all three sides, and it will also have like that ventilation so that the heat can be dissipated out.
Okay.
So that is a rack, right? So the same concept, eh, I am coming up with a rack to a two-wheeler, so that I can a placement I won't speak now, but I have a rack
Okay.
I can carry on my backpack, so
Oh,
that I will have a extra battery in it. And anyway, there is a battery in my vehicle itself, and I can replace my old battery or used battery with a fresh one. Invention is not that clear where I place it, but it is only talking about a rack, and I have an extra battery, and the existing battery, if it runs out, like I can replace it with this thing. So this idea is not very much clear
okay.
where I exactly place, and what I'm actually talking is useful, but it is obvious.
Yeah, the drafting
The
is
rack
very,
itself is useful, but it is obvious. So in this case, like if I only talk about the rack and the changeover, it will enable me to use another battery so that like I can travel another 150 200 kilometers. It's not enough.
okay.
So it is not enough, because the rack concept is something like once we started using EVs, like I had an idea that I can have an additional battery which can be kept in a rack, and that rack can be used additional battery source to a vehicle. But the placement of the rack, or whether I'm carrying always on my back, or the vehicle will have a slot so that like this rack can be fixed there, and an additional battery, how it is protected, or maybe how it is connected, all these things are still need to be I mean mm, need to be worked, and we have to come up with say drafting or showing the description, that like how it can be mounted in each of the vehicle. If it is a e-rickshaw, where it can be mounted. If it
Okay.
is a two-wheeler, where it can be mounted. If it is a buggy, where it can be mounted. All these things I have to show.
Okay.
So here, like the invention is useful, though it is obvious. It has some novelty as well, and we can show inventiveness as well if you can actually address the description part well.
Okay. Now this is
So the coverage.
this reminds me of what Harisa had mentioned. So when the disclosure is whatever the invention disclosure should be complying with the section 10 for industrial application, or it should be completely disclosed with the technical specification.
Yeah.
Yeah. So this is good, sir. So the role of the patent specification. So as we just discussed about how they need to be drafted, how does this examination process work here in India? So we drafted it, we filed it, um, but will the examiner know all the technicalities, or how does the complete process work, sir?
Yeah, before actually going how the examiner sees the application and what the examination report contains, so there are few other things like the examination request is not part of the patent application.
Okay.
So means examination request is a separate thing after application or along with application. So this is a clarity like many inventors doesn't know. So we can see some applications which are published but not asked for examination.
Mm-hmm.
So there could be a strategy when inventor knows like this won't get a grant, and I just file it and get it published and just use this status of publication saying like my patent is pending.
Okay.
That is one aspect. But I don't think like everyone uses. I see many applications published but not asked for examination.
Okay.
So the reason is they don't know this examination is one thing which is very important, and that is the purpose of actually filing an application.
Okay.
So why the request is separately taken is because this provisional and complete specification aspect concept. So provisional applications cannot be examined. For that reason, they detached this request for examination and made it separately. But people, I feel that way. I'm not sure, but I feel that way. So many people doesn't know the request for examination is something like we need to ask as soon as possible after complete specification.
Okay.
So that is one aspect. Like examination need to be requested along with complete specification or very soon, as soon as possible after complete specification filing. And the maximum time allowed to request for examination is 48 months. So which is annoying actually. Uh, why it is annoying is people just file applications, get it published, and they'll market it as patent pending. They won't ever go for examination, and this condition of 48 months is giving them 4 years of patent pending status.
Oh, good.
That means like they might exploit the market, saying like my patent is pending.
Okay. So
So this even this 48 months clause may not may I mean won't be existing in future. So they had an proposal for amending it, bringing it to 30 months. So it could be in the next amendment of rules like it will be only 30 months.
yeah, when you said
Anyway, so
they would exploit the market, is it again uh, killing the competitor, saying they have the patent pending? Is it in that way, sir? Or
yes, that way only. So they know there is a product, like maybe in some other country or maybe in India as well. So they know a startup is selling a product, and the startup is having a patent grant or maybe patent pending. And someone who wants to exploit it, he will also file an application with certain tweaking and say like I do have a patent pending, and he also starts selling it. So this settlement of that person, the first person getting a patent, and then he challenging this application uh, application, and the patent office decides like it is of no use or maybe it's not patentable. Then this everything will take time because of this condition 48 months. Like that is one aspect. And second aspect, like there is no other person, but I know like this is not patentable, and I file a patent application, and I start selling it as patent pending product.
So I have a quick question, sir. Now, if Chetak had launched its own EV series, which is in pre-booking, which we have seen,
Yeah.
Chetak Electric. But apart from that, I've also seen TVS also launch their EV series. So how does their inventions differ? Like the same thing. I had always this question: TVS Jupiter and Activa. So just change in the design and shape. Do they comply that they're unique, or how does it work with the competitors?
So we should go back to Mrs. Bench,
Okay.
Bhatta Bench.
Okay.
So if we are in that year, then in that year it is that only the three-wheeled vehicle or two-wheeled vehicle, which is which is an automobile. So then they have that right. So if they file a patent application, they have a right like no one actually can come up with a petrol powered or maybe some oil powered IC engined vehicle,
Okay.
because it is not there at that point in time. But now we know Chetak is a like uh, there is a popularity for it. Chetak, if Chetak re-comes into the market or relaunches into the market, the company as an EV, like people will be interested because of its shape.
Yeah, they're already,
So
sir. Yeah.
shape wise and the brand wise, like the trademark they have and the design they already had, but it is open to all now. But still, like they can only manufacture in that shape. Ambassador, Chetak, or maybe Yamaha RX 100, the companies can only market even now, relaunching in EV or maybe in other formats. But that's what IP is not, patent is not for everything in the product. It's part of the IPs will be part of the vehicle. So now Chetak EV or maybe Honda EVs or maybe some other TVS EVs coming up. So they are having some IPs for their EVs,
Yeah.
but not as a whole, not as a whole EV as a vehicle. IP is not for the scooter itself, because scooter is known.
Yeah, scooter
Scooter
is
is
no.
known, and
Yeah.
within the scooter now in the usage of EV, the present IP could be, or the present patent for TBS could be on the optimization of battery, or the present patent for Chetak could be something else.
Okay.
Yeah.
So, I mean, I'd seen like Vespa, they had their own new EV series launched with a showroom price and all. Again, it's too expensive. I don't know. EV should, I mean,
The designs are theirs. Vespa owns their design, like their USP, and they can only sell the vehicle in that shape, their model. Same with Chetak or maybe others.
okay.
And the technology they are sharing, like some startups. Yesterday we discussed about a startup. Its name, I guess. So they come up with. I gave this rack. I mean example also. One startup tried making a product like carrying an additional battery
Okay.
for actually powering the draining battery
Okay.
in the two wheelers in the EVs.
Okay.
So there are certain inventions, most of them optimizing the batteries or the running of the battery, I mean motors. So in EV segment,
Okay. Just like a battery box and all.
yes, yes.
I guess, I don't know if it's Seagull Enterprises or Hero Electric or Oben Electric.
Mm.
Oben
Yes,
Electric.
lot of people working in that direction.
Okay, looks like Open Electric, but again, different ball games. So jumping into the last question for this
We have
evening.
our clients, like we are supporting two startups. One is IPOG. They got two grants in this segment only. So regenerative energy for EVs.
Okay,
Yeah.
IPOG Industrial Patancheru.
Yes.
Okay, they say that.
Yes.
Okay, this is cool, sir. So the last question for this evening would be again, so the examination process before we jump into the examination process, this is what you explained. It could be 48 months or it should be less than that.
Yeah, we only talked about the timelines. So the examination request can be, I mean, need to be made by the inventors as soon as possible if they want the grant to be early.
Okay.
Because like the patent office criteria or maybe the wait list uh, is after the examination request only. Like they consider the examination request date to take up for the examinations. And after the examination request made by the applicant, the application will be examined now in two different queues. One is for the normal examination, and one is for the early examination. If it is early examination, there is a turnaround time of 40 days. Like they are issuing an examination report within 40 days after request after an early examination request is been received by the office.
Okay. Could you allow
And after the examination,
Suniji had raised his hand.
yeah.
And okay,
Just-
after the examination process?
So immediately after examination report gives us 6 months time to reply it,
Okay.
and we suggest like or anyone suggests if someone is looking for early grant, then we should not waste that time. So we should be giving a reply to the questions asked,
Okay.
and then the application moves to the further stage. It can be a hearing, or maybe it will be disposed as granted.
Okay. So if we could allow Suniji to join the speakers panel to control.
I'm trying actually somehow the page is not.
Okay. Harisai, can you give it a try? You also have the control. Okay, he's into the speaker. He's into the listening mode. Suniji, lower the hand and give it a try again. Like if you can lower the hand, again give it a try. Yeah.
I clicked it, but it's not
Maybe you can
moving into the speakers.
when you choose allow to speak, it takes some time. Sometimes it's tricky. LinkedIn is still working on this part. Sometimes people exit and they refresh and they come back.
Yeah, it's not moving.
Can you refresh your screen, sir? Maybe let's give it a try because I'm sure I wonder how other people are doing when there are. Okay, let's see. I guess the host. I see hundreds of people listening and people playing around with the same issues.
No, it's not.
Okay.
Anyway,
Yeah.
maybe Suniji, I
Okay.
think like you can hear us.
Okay. Wait. Let me give it a try from my end as well. I do have a control, right? Just give me a minute. Let me try from my end. With the our trademarks login. Probably that might kick you out if I log in from here. Let's see. Sometimes in multiple devices it does allow, and I'm just joining. One moment, sir. So let's see. Because when I log in through mobile, it removes from the other device. I mean, multiple devices is not enabled.
Hmm.
Suniji, can you raise your hand? Can you
Can you
still
still
hear
hear
us?
us? I have to relog in.
Oh,
Hello.
yes, sir.
Yes, sir.
Continue, sir.
Yeah, it was struggling to get this chance actually. So, anyways, I have one question to Srinivas sir. Sir, may I audible?
Yes, yes,
Yeah. So this is a very basic question. Being a law graduate, so I want to become a patent agent. So
yes.
can I practice both? I in court as well as a patent agent.
Yes, sir. This question, this is a, I mean, long pending resolution need to be given by Bar Council of India.
Yeah.
But yes, as it is Patent Act, you'll be practicing Patent Act, Trademark Act, Copyright Act, part of other acts. So there is no
So
bar on it.
no, can I
Definitely can
be an
practice.
attorney as well as a patent agent? Both. That's what
Yes,
was my
yes.
question.
You'll
Yeah.
be called patent attorney.
Because
There is no
I was
designation as
listening to
such.
some other speaker, some other forum, because they were specifically saying that this is not going to happen because either of the one we have to choose to practice the career, either a patent agent or you can become an attorney if you have a law background.
No, there is no bar, sir. Patent office doesn't say like
Yeah. Okay.
you
So we
need to
can
be
do
a
the
patent agent
practice. We can
for
take the
practicing,
cases, litigation
and
cases,
the
and we
bar
can.
says like if you are practicing patent
Hmm.
or trademark law, so the bar never said it is not it is not I mean acceptable thing.
Okay. Okay. Thank you for clarifying, sir.
Am I audible, sir?
Yeah. Yeah. I can hear you. Thank you for
Yes.
answering the question.
Yeah, but there is a long pending this resolution by bar. So other practitioners like other activities like professional activities
Yeah,
or
because I
businesses
read so
mainly.
many case laws also. Because being a doctor, he can't do the registration from MCA as well as Bar Council. That is also in
Yes,
a
yes,
conflict. So
yes.
similarly, I thought this would be also two professions similar to
It's not
that.
too
So
professional, sir.
yeah,
We
because we are practicing the patent law as well as we are doing an attorney job as well, taking up the
yes,
litigation cases in the court. So
yes.
I don't know. This is a commercial conflict. I don't know because that's what I was confused.
And the bar says like we cannot be a part of a business other than
Yeah,
the law profession.
yeah,
But this maybe I mean
yeah,
I myself actually I'm the promoter of this company, private
yeah.
limited company. But this company is mainly into only IPR services.
Okay, okay.
So we are not doing any other business.
So what my understanding was that anyone can become a lawyer, but anyone can't become a patent agent because we need to have some science background to
Yes,
qualify that
yes,
particular exam. Is that
exactly.
that is the point? I think. Yeah.
Yes,
Thank you, sir. Please continue. Yeah,
Yeah, thank you so much.
yes, Raj.
Yeah, thank you so much, sir. It's been, I mean, we'll continue with the rest of the series again tomorrow. But thank you, Sunitji.
yeah,
I'm sure there are thousands of them. Yesterday we had another
yeah,
lawyer, Lakshmi, I guess. She also joined in, tuned in live. She also wanted to explore
yeah,
this particular, I mean, field.
yeah.
But at the same time, there's so many other people who don't, I mean, they just depend on Google. But again, it's too confusing when there's loads of information out there. Uh,
Correct.
but always people look at the commercial aspects, mainly the Bar Council of India, probably many associations, they say that you are not supposed to have multiple sources of income, and they say so too many things. But as long as you are
Yep.
getting advice and there is no monetary benefit, you are in the field of education, I guess people can do whatever they wish to because it's
Yes.
their passion, or that's what I believe. Again, with Srinivas's experience filing thousands of patents, I definitely feel that it's more of kind of, I wouldn't say tuitions or education, it's sharing the expertise. But thank you so much, Srinivas sir. We'll tune in tomorrow. Thank you, Sai Teja and Hari Sai.
So tomorrow is also the same time, 5.
Yes,
This.
sir.
Okay.
We are testing the time differences, Sunitji. Sometimes we are
Okay.
checking people are
6
available at
o'clock.
7 p.m. or 6 o'clock
Yeah.
or 8
Okay.
p.m.
Okay.
So
I think 5 is also fine actually. Most of the people will try to finish their jobs also in the by 4:30 in India. So I think the
Yes,
5 to 6 is also good slot.
yes,
what's your feedback on 3 p.m., sir? That's something which we didn't try post lunch.
3 p.m. would be difficult because that's a business hour. So most of the people may not because
Busy in
sometimes
their
they
work.
might have. Yeah, yeah. By 4, I think most of the things will be closed.
Okay.
Any corporate or anyone, yeah. But
Yeah.
10 to 4 is a standard business time.
Okay. That's great.
yes,
Thank you for that feedback, quick feedback without a poll.
Yeah.
So thank you, Srinivasa. Let's tune in again tomorrow at 5 p.m.
yes,
Let's check if the algorithm helps us. Yeah. And
yes, sir.
tune into other
Sunitji, very,
episodes.
very much.
Yeah, thank you
Thank you for
everyone.
joining.
Yeah.